I seek to restrict myself to the arbitral process. There is a perception, and a perception we all agree perhaps, that our arbitral dispute resolution mechanism adds one more tier to the conventional litigation ladder system. Friends, I had said tier, T-I-E-R. I have not said T-A-A-R, because that would not be in singular, that will be in plural. First we have award, then objection to the award, then an appeal, then we have a strong tendency and urge to invoke Article 136 of the Constitution. Framers of the Constitution had put this article for a narrow slit window. But now the wall is demolished. It is being invoked massively. So that is invoked. And it doesn't end there. There is a constitutional remedy of review and judicially created curative petition. So, taken together, it can't be more arduous than it is at the moment. Chief Justice Chandrachud's concern that the arbitration space in India resembles, I'm quoting, so that I may not be misquoted. There is a strong possibility of it. So friends, I'm quoting Chief Justice of India, and I share his concern. But credit goes to him. He reflected, arbitration space in India resembles an old boys club. And next what he said, you can give testimonials for it, because your footprints beyond our national frontiers. And what he said was this: nowhere in the world is arbitration in such a tight fist control by former judges as in India. And this, friends, underlines the ground reality, and coupled with it, the pressing need to reform the system. I have no doubt you can't perform without reforming the system. Your center can do the job. An individual cannot bring about systemic change, because the individual is vulnerable to being taken on. But institutions are spirally strong, and therefore institutions can really resolve certain issues. And institutions are collective wisdom of a particular domain. Friends, it is equally imperative and high time we have a strong database of arbitrators drawn from wide fields: engineering, space, oceanography, infrastructure, aviation, space, sports. We have enough human resource in all these domains, and the kind so that quality of decision making by the arbitral process is enhanced, imparting credibility. A dispute is complex. To understand and appreciate it, you need to be beyond legal nuances. People who have lived in a particular domain are well suited, with your backing, to impart an award that will immediately find acceptance. Friends, examining and analyzing the issues in dispute resolution from a global perspective can be taken up by the research sector. I would indicate a small incident while I was in the court at Paris as a member. There was ICC arbitration clause. The issue was raised by an Indian party, and the issue raised was ingenious. That the clause says in accordance, not under, and therefore in accordance means we will have in-house mechanism to be in accordance with your procedure, but we are not yielding our jurisdiction. Similarly, let me narrate another incident I was involved with the global commercial arbitration with one of the public undertakings taking on a Brazilian giant for coal in Australia. Now we have, while drafting arbitration clause, party autonomy domain perhaps is escaping us when it comes to fine tuning. So the place of arbitration was Paris, New Delhi. So when they said they will have an attorney from UK and another from Australia, I said under Indian law, arbitral process is a judicial procedure, and we do not have reciprocal arrangement, and therefore it will not be in fitness of legal situation that these lawyers can assist us. Professor Lawrence, who, if I remember the name correctly, was the arbitrator. He took note of my objection and said he'll have arbitration at Singapore. My team was aghast. Loud and clear place of arbitration was New Delhi. They said we must challenge. I said no. Professor Lawrence, who had been with me in the court, a man of very sound discretion and deep learning, when I saw the entire clause in the arbitration act, you'll be surprised. We are in court. Party autonomy aspect only for subsection 1, not for subsection 3. And therefore you could do it. So these are the fine tuning which your center will empower youngsters so that they can come of age. Friends, these significant issues require systemic addressing if the nation has to emerge as a credible, recognized center for global dispute resolution. Let us make no mistake. We are not at the moment in the global room of arbitration. You have seen the rise of arbitration centers in Dubai, in Singapore. In our recent years, we have not had here. But we are a nation, friends, natural home to credible arbitral institutions. And why? Given our rich human resource, unprecedented exponential economic upsurge, and most important, what arbitrators local home, cultural depth. However, to secure our place in the global ecosystem, we have to strive more. We have to strive further. We have to act in concert. And that can fructify only when centers like this act at life situations. Friends, SILF and other stakeholders, and I'm so happy to notice that SILF is magnetic to the extent assistance from other stakeholders is required. Industry, commerce, and trade associations, they must converge to work towards evolution of an institution or institutions that can be at par with similar global outfits. It is not an occasion for me to reflect that we have two institutions, one under the Ministry of Commerce, another under the Ministry of Law. They may be doing a good job. I'm not fully aware. But when it comes to global benchmarking, they are yet to make the participant. Friends, our rich human resources are facet of governance, be it in economy, policy making, justice dispensation, and this is bound to be very healthy for us. Our rich human resource contribution is not limited to our geographical area. It dwarfs the entire globe. Towards achieving this a look at the statutory mechanism in the domain of arbitration because of priority and equality. I wouldn't say much of this for the constraint of time. But the entire world was made aware of arbitral mechanism by etc. A model was given. Reflect for yourselves, 1996, we had an unexpected sort in the UK. Where are we? How many changes we have undertaken and what changes have they undertaken? This research center, this body, can really be an eye-opener for the parliamentarians, for those who are engaged in legislation formulation. And mind you, we are living in times where these bodies are open to ideas, extremely receptive to these ideas.